Okay, so maybe I will begin. In Polish family law, entering into a marriage is aimed at creating a family and shaping a new legal situation of the spouses, which concerns personal and property relations. The marital property regime is a set of rules that determine what happens to property acquired during the marriage and what the mutual financial situation of the spouses is. Individual marital regimes also specify the issue of the liability of one spouse for debts incurred by the other and the possible method of dividing property after divorce. Referring to the property obligation of the spouses, they can be of two types. First, they may result from agreements entered into by one of the spouses in connection with running the household and meeting the ordinary needs of the family. In this case, the spouses are jointly and severally liable for the joint property, which means that the creditor may pursue their claims against any of the spouses, regardless of which of them incurred the debt or made too tortious obligation. Secondly, they may concern obligations in the scope of the spouse's property existing before the marriage and property acquired after it. In this case, in turn, the scope of property obligations is regulated by the Polish and Family Guardianship Code, depending on the type of property regime that the spouses may choose. The Polish legislator has provided for two types of regimes: the statutory community of property regime and the contractual regime. The statutory community of property regime is the most common form used by spouses because it arises automatically by operation of law at the moment of entering into a marriage. It has a model character and is preferred by the legislator, who considers it optimal for a typical average family supported by the spouses, hard work, and having primarily consumer goods. In this regime, the right and obligation to manage and liability for incurred debts refer to the joint property acquired during the duration of the community of property by both spouses or one of them. It will include the remuneration received for work and income from other gainful activities of each of the spouses, from business activity of running a farm, income from the joint property, and from the personal property of each of the spouses, funds accumulated in an opened account or an employee pension fund of each of them. The calculations are examples. The legislator hasn't created a closed list. In the case of receiving remuneration, we are dealing with any type of employment contract. Community ownership applies not only to the employee's salary itself, but also to their bonus, remuneration, allowance on pension. Remuneration also includes retirement pension, disability pension, social benefits, and scholarships. Another joint property of spouses is income from renting an apartment, interestingly, regardless of whether it was joint property or personal property of the spouses. Joint property will not include property acquired before the statutory community of property was established, most often before marriage, as well as certain property rights acquired during the duration of the community of property, which include items acquired through inheritance, bequest, donation, items obtained as compensation for bodily injury or health disorder, awards for personal achievements or copyrights. The statutory community of property regime is not the only and primarily not a mandatory system regulating community of property. Spouses may enter into an agreement between themselves in which they will regulate their relations differently. Such an agreement is usually called a premarital agreement. It can be established both before and after the marriage. A premarital agreement, which takes the form of a notarial deed, specifies which assets are common and which remain the personal property of each spouse. By entering into a premarital agreement, spouses may extend, limit, or exclude the statutory community of property, leading to the separation of property. Extension of statutory community, the spouses include in their joint property the items and property rights that previously belonged to their personal property. These include those that were acquired by them before the marriage or were used to satisfy personal needs and perform a profession. According to Article 49, paragraph 1 of the Family and Guardianship Code, spouses cannot extend the joint property to property items that will come by way of inheritance, bequest, or donation, property rights arising from joint ownership subject to separate provisions, rights of partners in a civil partnership, inalienable rights that can only be granted to one person, the right to maintenance, the right to remuneration, claims for compensation for bodily injury or health disorder or compensation for harm suffered, not yet due claims for remuneration for work or other gainful activity of each spouse. Limitation of statutory community, spouses exclude from their joint property certain types of property and property rights. These include remuneration for work and income from personal property. Exclusion from the community may occur in the future, but may also apply to property items already belonging to the community. In such a case, the personal property of each spouse includes a share in the fractional co-ownership of these items. Limiting the community cannot lead to its complete abolition. It can be divided separation of property in two ways. The first type is full and permanent separation. The second type is separation with equalization of acquired assets. The first type consists in the fact that the spouses retain not only their previous assets, but the personal assets of each of them will also include assets acquired later. The effect of this solution is that each of the spouses will manage their assets individually. However, if the spouses have contractually excluded community of property during the marriage, this community ceases at the moment specified in the prenuptial agreement. Then the community property is divided. Despite choosing this regime, the spouses may be co-owners of the thing in one half of the part. Separation of property with equalization of assets means that during its duration, spouses have only personal assets, whereas after the termination of this system, due to the dissolution of the marriage by divorce, there is an obligation to equalize the assets of both spouses. In this way, the interest of the spouses who for various reasons has less assets than the spouse, for example, as a result of raising children and not taking up gainful employment, are protected. Sometimes the demand to equalize the assets will be immoral due to the reprehensible attitude of the other spouse, manifested by a reluctance to work, squandering property, alcoholism, or a drug addiction. The definition of property management is included in Article 36, paragraph 2 of the Family and Guardianship Code, which states that each spouse may independently decide on the joint property. However, spouses are obliged to cooperate in its management and should provide each other with information. In the event of a deterioration of the financial situation, the independent management of the joint property might be limited or deprived. A spouse has the right to object to the performance of property activities by the other spouse. These activities cannot include everyday matters, meeting the ordinary needs of the family, or conducting commercial activities. The most common situation in which consent is necessary is the performance of activities by spouses in order to sell, encumber, or acquire real estate for a fee. Consent is not required to rent a building or premises because it is not regulated in Article 37 of the Family and Guardianship Code. The consent of the spouse is also a necessary element in the case of a donation from the joint property of the spouses. Now we can see advantages of joint property of spouses. And it's, for example, joint property management strengthens the bond and trust of spouses, financial protection for the weaker spouse as a safeguard for the future, easier to get bank loans, simpler settlements after the death of one spouse, meaning that the joint property automatically passes to the other spouse, which simplifies inheritance formalities. Uniformity of assets simplifies everyday functioning and financial decisions. And disadvantages: liability for spouses' debts, lack of autonomy resulting in the requirement for the consent of the other spouse and delay in decision making, complicated settlements in the event of a divorce, difficulties in running a business, and potential risk of losing joint property in the event or irrational decision by the spouse. And advantages of separation of property is full financial independence without the need to obtain the consent of the other spouse, protection of assets against spouses' debts, recovery of repayment only from personal assets, easier business management but making quick business decision and no worries that decision will affect the other spouse's assets, no need to divide property in the event of divorce, protection of personal assets, meaning that assets remain the sole property of the individual, which can be beneficial in family situations where one spouse has children from a previous relationship. And disadvantages of separation of property is no protection for the economically weaker spouse, potential problems with joint investments which come down to determining the share of each spouse, less motivation to plan financially together, leading to a weakened sense of community in marriage, difficulties in obtaining laws related to the creditworthiness of each spouse individually, and conflicts in household settlements, that is determining who pays for what and how the costs of maintaining the household are divided. To sum up, there is no clear answer to which property regime is more beneficial for spouses. The choice between community of property and separation of property depends on many factors, such as the professional and financial situation and personal preference of the spouses. Each of these regimes offers different benefits and risks, which in practice may have a different impact on the functioning of the marriage. Community of property may be more suitable for married couples who want to build joint property and operate on the basis of trust. In turn, separation of property is more beneficial for couples who value financial independence and want to protect their assets. From a legal perspective, I think that separation of property often offers a greater sense of security and simplicity in legal proceedings, especially in the context of divorce and protection from debts. Community property, on the other hand, can be more complicated in the case of legal disputes, but is more beneficial when spouses cooperate and share responsibility. When choosing a form property of regime, it is also important to consider the potential situations in which spouses may find themselves in the court. Thank you.